A number of facts in this case had been established in the course of the inquiry. Nora Anne suffered from a condition where her brain did not develop normally. This condition affected her in a number of ways. She struggled with balance and coordination, and while she could walk just fine on flat surfaces, when the terrain became uneven, she would often fall. Indeed, on the day that the family arrived at the Dusun, she had fallen when walking along the trails within the compounds of the resort. Nora Anne did not have the agility or coordination of the average child of 15. She also lacked manual dexterity and she tired easily. Her headmaster at school testified that her disability may not be immediately obvious. In addition to these physiological limitations, certain aspects of her psychological outlook was also relevant in the present context. The trail in the resort, in the compound of the resort, which the family had walked on the day of their arrival at the resort, was for the most part paved. Where it was not paved, the terrain was manicured. And what I mean by manicured was that it was planted with grass. Even though the path was steep in places, it was nothing like walking along a path in secondary jungle. Nora Anne's body was found on the 13th of August in what I would term as secondary jungle. The area was a forest that had been cleared a number of years previously and then planted with oil palm. As a result, secondary growth had set in. The path to get to where Nora Anne was found was challenging. In her written grounds, the coroner considered the contention by the family that Nora Anne had been kidnapped. She ruled out homicide as a verdict, and correctly in my view, because there was no evidence to support foul play. At paragraph 167 onwards in her grounds of decision, the coroner analyzed the verdict of misadventure and correctly reminded herself that if there was no evidence to support a verdict of misadventure, then she must return an open verdict. She then recited a chronology of the relevant circumstances in this case and concluded as follows. And I read from paragraph 173 of her decision. The existence of the above said proof facts for me is sufficient on the balance of probabilities to lead to the inference that Nora Anne had gone out of the Sora house on her own and subsequently got lost in the abandoned palm oil plantation. And there was no person criminally concerned in the cause of her death. In paragraph 174 of the decision, she set out what she described as the reasons for her verdict of misadventure. Having examined the grounds, the written grounds, and these reasons in particular, I am of the view that the learned coroner was in error to have returned a verdict of misadventure. In my view, it was not probable for Nora Anne to have ventured out of the Sora house on her own, to have navigated by herself the challenging terrain in and around the location where she was eventually found, and to have evaded detection for 6 days while the extensive search and rescue operation was being conducted. Sora House was the house within the resort in which the Quoirin family was staying. If she had left the Sora House on her own, she would have had to either clamber over the broken fencing located on the western border of the Dusun resort, or to squeeze her way between gaps in the gate at the rear of the resort. This would not have been impossible, but would have been very difficult for a person with Nora Anne's physical condition. In addition, if she had left the Sora house on her own, it would have been likely that it was still dark at the time, which would have made the trek doubly challenging, given that the resort was located on a steep hill and any which way down would have required a person to navigate the steep terrain. In addition, there was also evidence that there was no lighting within the compound of the resort. Once out of the boundary of the resort, the terrain will have increased in difficulty. In order to get to the location where she was eventually found, she would have had to cross rocky stream beds and to go up and down steep slopes. The terrain was challenging even to those able-bodied men and women who visited the site on the 24th of May this year, who were all well equipped for the occasion. I found it extremely unlikely for Nora Anne to have been able to navigate the same terrain barefoot. In addition, the objective evidence established that Nora Anne had been alive for approximately 6 days from the date she went missing. In order to support a verdict of misadventure, the coroner would have had to find that it was probable for Nora Anne not only to navigate the challenging terrain with her physical infirmities and bare feet, but also to have avoided detection for those 6 days, while the extensive search and rescue was being undertaken. It was common ground that vast resources was put into the search effort, involving different agencies, sniffer dogs, and drones with infrared detection capabilities. The balance and coordination issues she faced, together with the fact that she tired easily, established, in my view, that it would have been unlikely that her death was the result of misadventure. More than Nora Anne's physical condition, there was also uncontroverted evidence regarding her psychological outlook. She was a shy and retiring child who was uncurious and unadventurous, and who was strongly attached emotionally to her parents. She was also uncomfortable with the unfamiliar. She was not a rambunctious urchin who had to be constantly held in check from exploring every nook and cranny of her environment. Now, these facts taken together establish that it was unlikely for Nora Anne to have gone out on her own. I am therefore constrained to substitute an open verdict in place of the verdict of misadventure returned by the learned coroner. As I had mentioned earlier, I have every confidence that the learned coroner had sought to take every care and diligence in undertaking the inquiry. However, having reviewed the material that was before the court, I am of the view that the verdict of misadventure ought to be vacated in the interests of justice and substituted with an open verdict, as there was no credible evidence to support any other verdict. It has to be remembered that the role of the inquiry is not to ascertain which of the competing verdicts had the highest possibility of being the correct verdict. I am willing to accept that on the evidence before the court, the possibility of third-party involvement was lower than the possibility that Nora Anne had somehow inadvertently gotten herself into a situation from which she could not extricate herself. That does not mean, however, that I should enter a verdict of misadventure, for I must assess whether misadventure was more likely than not the reason why Nora Anne met her demise. Given the evidence that was before the court, I fail to see how it could have been said that it was more probable than not that Nora Anne had died as a result of misadventure.